Hello and good evening, everyone. I'm back with another very important topic, which forms the subject matter of Judicial Services exam, that is Section 80 of Code of Civil Procedure. Whether notice which is supposed to be sent under Section 80 of Code of Civil Procedure, that is CPC, whether it is just an empty formality. On 25th March 2025, the Supreme Court has made it abundantly clear that it is not just a formality, it is not just a ritual, but a legal mandate with a purpose. In the matter of Yerikala versus State of Andhra Pradesh, the Supreme Court has came down heavily on the state government for ignoring the notice that was sent under Section 80 of CPC. But before we go into the case, let's understand what is Section 80 of CPC. According to Section 80 of CPC, no suit shall be instituted against the government or against a public servant for any act which is purported to be done in their official capacity. In this regard, notice. The idea is very simple. The idea is very simple. It is to enable the government to settle the issue. There is a possibility to unnecessary litigation, then it is for everybody's benefit, right? It saves a lot of money, a lot of energy, a lot of time of the parties as well as that of court. But sadly, or rather unfortunately, the Section 80 notice has not been given the respect it deserves. They are usually taken for granted. They are usually ignored by the authorities. Now, in the present case, the appellants claimed ownership and possession of land since 1970, and their claim was based upon official records and continuous possession. The government in 1995 took their land without any notice, without any compensation, without following due process. And in response, the appellants, they sent a notice to the state government under Section 80 showing their intention to institute a civil suit. But what did the government do? Well, the government simply ignored it. They did not do anything with it. So naturally, the appellants had no choice but to institute the suit, which they did. The trial court decided the matter in favor of the appellants, but the High Court reversed the decision. The High Court found that it held that the land in question was covered by Andhra Pradesh. There was an act of 1977, Andhra Pradesh Assigned Lands Act of 1977. And when a land comes under this act, it automatically reverts to the state government. And this act has a retrospective application. So the appellants, they came before the Supreme Court against the decision of the High Court. And what followed was not only the recognition of their rights, but also the importance of Section 80 was highlighted by the court. The court invoked uh, Section 113 of Bhartiya Sakshya Adhiniyam, which was earlier 110 of Indian Evidence Act, under which a presumption of ownership can be raised on the basis of a continuous possession. Right? Presumption of ownership is raised on the basis of continuous possession. What is the effect of this presumption? Now the burden will be on the opposite party to disprove. So here the burden was on the state government to disprove the ownership of the appellants. And the state government had not given any proof. There was nothing from the state government. Then the Supreme Court criticized the attitude of the state government towards the notice that was sent to them under Section 80 of CPC. The court acknowledged that this is a usual practice on behalf of the authorities, that the notice under Section 80 is simply set aside. It is simply kept in abeyance. No response comes from the authorities. Right? The least that they can do is reply to this notice, state their position, whether the claim has been recognized, whether they want to contest it, or they want to come at a settlement. If they keep themselves silent, then naturally this silence will result into litigation. And such kind of litigation can be a wasteful exercise, a waste of public money, a waste of energy, a waste of public trust. Right? Some very important observations have been made by the Supreme Court, particularly in para 113. Let me just show you. See, here the Supreme Court says the purpose of law is the advancement of justice. The least that was required in the present case was for the state authorities to acknowledge the notice issued and inform the appellants them as regards their stance, right? As to what is their position. Then here, it is observed that they are expected to let the plaintiff know their stand within the statutory period or in any case before he embarks upon the litigation. In certain cases, courts may be obliged to draw adverse presumption against the public authorities for not acknowledging the notice or telling the plaintiff of its stand, and in the absence of that, a stand taken during the course of trial may be considered as an afterthought. So what the court is trying to indicate here, if nothing is coming from the authority in reply to the notice, then adverse inferences can be drawn against the authority, and whatever stand the authority subsequently takes during the trial, it can be considered as an afterthought, right? Which means there was no cause on their behalf initially, and then they are simply putting up a moonshine defense against the cause of action, right? Then apart from this, 107 to 109, they are also important paragraphs. You will find some very good observation regarding Section 80. See, 107, the court has cited a precedent from 1978, the state of Punjab versus Geeta Iron and Brass Works Limited. This is a very, very important precedent as far as Section 80 of CPC is concerned, where Justice Krishna Iyer emphasized the need for accountability of governments regarding wasteful litigation. So here, Justice Krishna Iyer has said that when the government enters into unnecessary litigation, then it is not only the moral irresponsibility on behalf of the authorities, it is also economic irresponsibility, right? Unnecessary expenses will be um, occurred. They will be incurred, right? Then 108, however, Section 80 has become more a ritual. Here, the court acknowledges that it has become a normal practice that no attention is paid to Section 80 notices. Then again, 109, quoting Justice Krishna Iyer, the court has indicated that Justice Krishna Iyer advocated for a litigative policy that prioritizes conciliation over confrontation, suggesting that it should be a directive for the state to empower its legal officers to resolve disputes rather than prolonging them in court, right? So there should be such kind of policy on behalf of the state. Then in 110, the Supreme Court has quoted a paragraph from the same judgment where you can see that Justice Krishna indicates that Section 80 has been kept in the statute despite the fact that Law Commission recommended for its deletion, right? So we must respect the intention of the legislature here. The intention of the legislature is that the state and its instrumentalities, its authorities should not be indulging in unnecessary litigation. They should try to settle the disputes with citizens and not engage them as if it is a battlefield. So the legislature has put such kind of confidence on the shoulders of the state and its authorities, and the same should be respected, right? So the bottom line is this. The bottom line is this, that uh, whenever there is a Section 80 notice, whenever the citizen knocks the door of the state with a Section 80 notice, the same should be respected. The citizen deserves an answer. He should not be met with silence, because as I have said, that silence will take you to the courts. The state, the intention should be to settle the disputes with the citizens as amicably as possible without getting into a battlefield, right? That will go a long way as far as building trust is concerned, right? And the state can indulge itself in more fruitful activities rather than contesting with its own citizens, right? So that's all. This is a very important decision from the Supreme Court, right? Section 80 has been discussed at length, and I always say that you should read the full text of the judgment, though we try to bring them to you in as simplified way as possible. But if you want to learn the law, then you must go to the letter of the law, how the courts are interpreting. I always say that it will be a beneficial exercise. It will improve your language also, and um, the the law is such that as much as you will read it, more things, more clarity will come to you, right? But our endeavor here is to make things as simplified as possible for you. We read and we deliver. Now, on that note, a quick update is there for every judiciary aspirant. Live Law Academy has launched its new batch. It will start from May. Now, Live Law Academy offers two courses, JSEP 2.0 and JSEP Lite. Under JSEP 2.0, the classes will be very comprehensive, including legal GK, case compilations, detailed notes, etc. And it will cover more range of subjects. Whereas JSEP Lite is, as the name itself suggests, it is a lighter version where uh, the coverage will be comprehensive in terms of the subjects that will be covered, but it will bring some flexibility in the overall schedule and in the overall process as things will proceed. And it will be very beneficial for the working professionals and those who are still juggling with their law colleges. So do check them out. And the benefit is that we bring retired High Court judges to train you in tissue. And the endeavor is not only to make you qualify these examinations, but to shape your overall personality so that you contribute to the institution in the fullest way possible. So do explore these courses. And if you have liked this video, then do share it, comment, like, and subscribe so that you do not miss any important update regarding the law in general and latest updates in specific. Thank you very much. Have a really good evening.